Okay, we're live.
All right. Good morning, everyone. I'd like to call to order and welcome you to the Judiciary Committee's informational forum this morning on the state's family court system and certain reforms that are proposed by the judicial branch. I want to start by thanking Judge Albus and Judge Carroll on behalf of the branch, whose idea was to pull this together and to brief the Judiciary Committee on some of the reforms and the proposed rule changes and the like. The Judiciary Committee does have a public hearing later today, and I do want to obviously keep this narrowly tailored. So we will have a hard stop at 11:30 today in order to allow members and staff a short break before we start our public hearing at noon. So I know Judge Albus is going to make some introductory remarks, and I'm sure we'll take some questions, but I will obviously ask members, if you can, to keep your questions narrow. We can always follow back up with Judge Albus. This is not a formal public hearing on a bill before us, but rather supposed to be informational and a high-level briefing. So let's do our best to keep it to that. With that, I would like to just, if there's any remarks from Senator Winfield or Representative Fishbein.
Nope. Sure. Thank you. Good morning.
Then we will jump into it. Judge Albus, the floor is yours. Thanks for being with us.
Morning. Thank you, Representative Staffstrom, and good morning to you and to Senator Winfield, Representative Fishbein, Senator Kissel, if he's with us, and to all the members of the Judiciary Committee. I thank you for the opportunity to appear here today to talk about the reforms that we are instituting in the family court. I'm joined this morning by Joseph DeTuno, who's the Deputy Director of the Court Support Services Division for Family Services, and he will be helping me in this presentation. And we're going to keep it well within the time Representative Staffstrom indicated, so that there is time for questions as well. Several factors in recent years have caused the judicial branch to re-examine the way that it handles family court cases. There's been a growing awareness that the one-size-fits-all adversarial model does not serve Connecticut families well. There are times where adversarial litigation is the only way to resolve a family case, and there are other times where that may be the method that the parties prefer to use, and that will always be available to them. But family cases are inherently different than civil cases like lawsuits about car accidents or breaches of contract, and it did not make sense to us, to the judges and administration, to force all parties into that adversarial process, especially given something that is more prevalent in the family division than in the civil division, which is the prevalence of self-represented litigants. In a given year, typically in about 85% of family cases, there is at least one party who does not have an attorney, and in most cases there are two. And it became especially burdensome to try to resolve cases through an adversarial process that most self-represented litigants just were not equipped to negotiate. There's been a shift generally in this field, as evidenced by the more and more common methods used by parties to resolve their family matters before coming to court, through the use of mediators or collaborative attorneys. Another factor was that we did a survey of family litigants in Connecticut a few years ago, and the biggest complaints that litigants had concerned the number of times that they were required to come to court during the life of their case, and the amount of time that they had to spend in court on each of those occasions, often with very little to show for it. And we realized that there was legitimacy to those criticisms, and it's something that we sought ways to address. And unfortunately, another phenomenon that has become more common is the use of the process, typically by a self-represented litigant, to wage a form of abuse against the other partner in the relationship. It's often a litigant who's had a history of other forms of abuse, physical or emotional, but the process that we had lent itself toward allowing one party to repeatedly bring the other party back to court frequently in a way that was abusive. And ultimately that could be controlled by the court and by the judge in the case, but not before some damage was done. At the same time, there were national studies being done by independent court experts that came to similar conclusions and made national recommendations as to the best ways to change the family court process to better serve families. The National Center for State Courts was one of the leading groups involved in that effort, and we were fortunate to obtain a grant to use their assistance in analyzing our old process and developing a new one. And the national recommendation that came out in a report by the Family Justice Initiative in 2019 was for courts to use two main principles in family court cases, the principles of triage and pathways. Triage meaning the early analysis of a case and its needs and what the court could do to help those parties to a resolution. And pathways meaning having differential approaches to cases depending on their needs instead of funneling all cases through the same process. And what we hope to do today is to provide an overview of what the new process is in comparison to the old. So Deb, if you have the PowerPoint presentation, I think at this point, we could show the first slide beyond the title slide. I'd like to just first go over what the process was under our old procedures. And I know many of you are familiar with this, but for those who aren't, I just want to quickly go through a typical divorce case and what the process was before. The plaintiff started the case by having papers served on the defendant. Those papers would include a date called a return date, which wasn't a time for the parties to actually come to court, but merely a date for the defendant to file a written appearance acknowledging that the case had begun and that the defendant intended to engage in defending it and participating in it. The first date set by the court was scheduled about 90 days after the return date. It was called a case management date. And that 90-day time period was tied in with the 90-day statutory stay under our general statutes, whereby, with some exceptions, once a divorce case is started, no judgment can be entered before 90 days from the return date. And the intent of that was to provide a sort of a cooling off period to make sure parties didn't rush into a divorce judgment. So the date was set with a view toward making it possible for the parties to conclude their case on that day if they had a full agreement. On the case management date, the parties or their attorneys, as they were represented, would inform the court as to whether the parties had an agreement or not, or perhaps had a partial agreement. Maybe they agreed on financial issues, but had disagreements about parenting issues or vice versa. If they had a full agreement and were ready to go forward, they might actually get their divorce judgment on that case management date. Otherwise, they would likely have to come back at a later date if there were children involved and it appeared that family services could be of help to them in one of the ways that Joe will talk about a little bit later. The court might order that those services begin on that date, or the parties just might need some more time to try to negotiate. Likely that case would be continued to a date on our short calendar to see where the parties stood then. Next slide, please, Deb. In the meantime, the parties could file motions for temporary orders while the case was pending. They could file those anytime after the return date. So there could be motions filed even before that case management date. And every time a motion was filed, it would appear on our short calendar. The motions might concern matters such as temporary child support or alimony while the case was pending, temporary custody orders while the case was pending if there were minor children, or orders about the use of the family home. But in any case, each side could file a motion, could file as many motions as they wanted, and every time a motion was filed, it would automatically appear typically 2 or 3 weeks later on the short calendar, and the parties would have to come to court on that day. And when they got to court, there would be a courtroom full of people who had cases where motions were filed around the same time, and the judge would call the list to see who was there and ready to go forward, and would normally direct the parties and counsel first to meet with family services to see if some agreement could be reached on the specific motion or motions that were on the calendar that day. And after waiting to meet with family services and either reaching an agreement or not, the parties would return to the court and have a brief appearance before the judge, which would result in perhaps the approval of their agreement if they had reached one. If they required a very, very short hearing, that could be possible on a short calendar day. And by short, I mean 15 minutes or a half hour, maybe sometimes approaching an hour, if that were all that was needed. And if it weren't a particularly busy day on the calendar that day, the judge might be able to actually hold the hearing. But if anything more was required in the way of a hearing on a motion, it would have to be either deferred to a later short calendar or more likely scheduled for a special hearing on a non-short calendar day. The court again might also order some services to address the issues the parties had, especially about parenting matters. And this process could repeat without limit. And it was not unusual in certain cases for parties to be back at court on an almost weekly basis, or at least 2 or 3 times a month for months at a time. They had long waits. They had little time before the judge. Just by way of example, I'm the presiding family judge in Middletown. I'm the only dedicated family judge. Sometimes I had help on short calendar days. Sometimes I didn't. If I were doing it alone, it wouldn't be unusual for there to be 60 cases that were marked ready to go on the short calendar day. And if you do the math over the course of a full court day, that works out to about 6 minutes per case. So that gives you an idea of how little time the court might have for a given case on a short calendar day. Next slide, please, Deb. There were several negative impacts of the short calendar process. Parties had to miss work frequently on short notice or arrange for childcare, often at significant expense. On short notice, they spent a lot of time waiting for brief meetings with family relations and brief court appearances. And when they had those meetings and court appearances, the focus was on the immediate motion at hand rather than resolution of the entire case. So even if an agreement were reached, it was in some ways like a Band-Aid, addressing one small part of the case and not talking about the bigger picture and not making a plan necessarily to have to resolve the whole case. That courtroom full of people on short calendar day, some of them had fairly simple matters, others had very complex matters. They were all there together. Sometimes the people with simple matters had to wait a good portion of the day to get their turn. And sometimes in a very busy court, on an especially busy day, the court might run out of time and have to tell parties to come back on another day. And as I said before, an abusive partner could use this process because you can pretty well tell when a motion is likely to appear on the court calendar by virtue of when you file it. And some self-represented litigants were not above trying to file a motion so that it would come up at a time that they knew would be inconvenient for the other party. Finally, when parties had exhausted their pendente lite temporary motion litigation, There would come a day at the short calendar when they told the court that they were ready to have a trial assigned. Sometimes, often with the prompting of the court to ask, when are we going to really get to the end of this matter? And at that point, the trial date that might be available for the matter could still be further months away. And during that time, other things could happen, more motions filed, more trips to short calendar. So it was a very difficult process. It was expensive, and it didn't allow the court or the parties or family services to have the time they needed even to address the immediate issues at hand, let alone the overall case. Next slide, please, Deb. Under the new process, there will be major differences in the way things are scheduled. Parties will still have the right to file any motion or pursue any relief that they could under the old process, but the court will be taking control and is taking control of the scheduling to try to do things in a more logical manner and to give each case the attention that it needs, rather than making everyone come on the same day at the same time, no matter what their issue is. And the first step of the process is to triage the case early on and to put it on the best pathway for that case. I think at this point, though, before we go further, I'd like to ask Joe to talk a little bit more about what happens at triage, which occurs on a date that we call the resolution plan date. Joe, I think you had a slide. I'm not sure if it's out of order or...
No, you're on to the next slide.
The next slide after this? All right, why don't we do this and then I'll go back because my comments will make more sense after you've spoken.
Good morning. I'd like to provide a brief overview of family services just to set the stage. We have 131 professional staff statewide. They're called family relations counselors. They're judicial branch employees within the Judicial Branch Court Support Services Division. And on a daily basis, our job is to provide support for the judges of the Superior Court. This was especially evident during the past year with COVID, where our dedicated family relations staff worked every day helping to move the court's business in concert with our other judicial branch colleagues. We've been providing services within the family court for well over 60 years, and all services are provided at no additional cost to the parties. Our historical role in family court is to assist families to address parenting and financial disputes, help facilitate the efficient movement of matters through the court system, and most importantly, lessen the impact of conflict on children. In our initial meeting with the parties at the resolution plan date screening, we have several goals. The first is early intervention, especially for the high number of self-represented litigants utilizing our court system today. We should be determining what the current level of need is. We should be matching the resources to the level of conflict and complexity, and we should be doing this as early as possible, hopefully leading to better outcomes. This emphasis on early intervention has been an ongoing priority within the judicial branch for the past several years. Another important goal is to identify conflict early on. Issues such as domestic violence, mental health, substance abuse, or any issue raised that could impact the capacity to parent or co-parent. We also want to deal with proactive versus reactive practices. With reactive practices, I feel there are many missed opportunities. I was a family relations counselor a long time ago, and in court, I know we missed opportunities to help parties because the dispute had moved on and they didn't enter the system till well into the time of their divorce. Being proactive as a system maximizes the opportunities to not only educate litigants about the process, but assist the parties to reach resolution. We'd also like to have a standardized and solution-focused approach for all new cases, moving away from the inefficient Band-Aid approach of the old process. In the new process, our cases will be handled in a much more holistic manner. And finally, our main goal is that the screening or the initial time parties meet with family services will lead to something called differentiated case management, where we know one size does not fit all, as Judge Albus talked about, and more court resources should be allocated to and focused on the complex cases. Family services' role in the initial screening is as follows. The screening is the initial meeting for a family entering the system. It will be a forum for the parents to obtain information about the process and the most effective pathway to resolution. We want to involve and empower the parties to be part of the process and be part of their solution. The role of family services is to explore the areas of a particular filing, a divorce or child custody case, in a global fashion. As part of the initial meeting and screening, we will lead a broad and educational discussion with the parties relative to their case, not the individual motion that is before the court, but their case, and determine if the parties have talked about the major components of their case. Most parties, especially the self-represented litigants, come unprepared. They don't talk to each other about the issues or the possible solutions. So this may be the first time parties sit down and discuss the issues. We'll assess how the parties view the matter and what the individuals indicate are areas of general or final agreement. If on the day of screening, our hope is the parties will be able to resolve all the issues and a full agreement will be possible. If this is the case, we'll report this to the judge. If a full agreement is not possible, our family services staff will strive to accurately predict, based on the information provided by the parties, the amount of court resources necessary to resolve the existing disputes and exit the system. At the conclusion of the screening, the family relations counselor will recommend to the parties, their attorneys, and the judge a resolution plan. This plan will include a recommended track and whether a referral to family services is necessary to resolve the remaining disputed parenting or financial issues. Family services can recommend further negotiation, our early intervention program, mediation, case management, or evaluation. I'd like to stop and make a point of emphasis. Family services and our family relations counselors only makes recommendations to the parties and their attorneys. It is the judge who assigns the cases to a track, orders referrals to family services or other services, makes temporary orders, and then determines the scheduling of future court events. If the parties don't agree with the recommendations of family services, they do have the ability, as Judge Albus mentioned, to go before the court. But again, family services will make those recommendations to the parties. Overall, and I think most importantly, the screening is a major opportunity for family services to help resolve a large number of cases early in the process. These cases can be disposed in the beginning stages and much more efficiently. We've been screening cases since December 1st, 2020 to the present, and the early outcomes are encouraging. We've completed 1,126 screens. 700 of those cases were completed with an agreement, which equals 62%. This early data compares very favorably with our historical outcomes. If you provide a safe setting for the parties and an opportunity for them to sit down and discuss concerns and solutions with family services, well, now we're doing this virtually, but if they're able to sit down, have communication, and have a safe environment, people are able to reach solid agreements that work for them and their children. Judge Albus is going to be talking about the different tracks in a few minutes. Family services, again, will provide support and assistance to the court on specified Track B and Track C court dates by offering negotiation services as determined by the judge. The goal in Track C cases, or the more complex cases, is for that case to have one specific family relations counselor and one judge assigned to them throughout the pendency of their case if they have child-related issues. This way, the parties will not have to meet with an unfamiliar staff person or recount their parenting history and their issues, and we feel this will lead to better efficiency and will maximize each court appearance for those individuals. Thank you. Judge Albus?
Thank you, Joe. Deb, if we could back up one slide. please. Sorry to jump around like this. The goal of that triage will be to help the court set a course for the rest of the case. And the triage is designed to happen at a resolution plan date within about 45 days after the return date, compared to the former a 90-day case management date being the first time we call the parties to court. So we'd be getting an earlier look at it. And with the benefit of the information that is gleaned at the resolution plan date and the recommendations of family services, the judge will be able to put the case on an appropriate track, which will have the goals of reducing the number of times that the parties have to come to court, allow enough time on each court date for meaningful progress, to eliminate the long waits that we had on short calendar to see family relations or a judge, to reduce the opportunities for abuse by litigation, by having a more logical schedule for future court events, as opposed to another court date every time a motion is filed, and thereby reduce the parties' expenses from lost work time and child care costs. And the ultimate goal is to help parties bring their cases to closure sooner and to reach better outcomes for families. But Deb, if we could go ahead, like 2 slides now. So after the parties have met with family services on the resolution plan date, a judge will assign the case to a track considering the recommendations of family services, and especially if either party disagrees with those recommendations after giving both parties an opportunity to be heard. The track A cases don't really require much in the way of a future scheduling order. These might be parties who didn't really have much disagreement to start with. They figured out enough about the court process without lawyers to get their case filed, and then they just weren't sure what to do from there. And they needed some guidance from the court just to tell them how to effectuate their agreement, how to put it into place, and how to seek approval of it. And on those cases, and I've had some of these already, thankfully, on the resolution plan dates that we've had here in Middletown, after the parties have met with family services, they've come before me in a virtual hearing. I've heard their agreement. I've approved it, and their case has been done. The other situation that might lead to a case being on track A is where the parties essentially have a full agreement, but maybe didn't have quite all the information that they needed to finalize it on that very first court date. Maybe someone didn't have their most recent paycheck to help family services calculate the child support guidelines, for example. And they agree in concept, they just aren't ready to present it to a judge yet. They need to fill in a few details. They may need one more court date later to do that, or a little more help from family services, but they don't need a formal scheduling order. They're essentially ready to conclude their case. And that leaves the other 2 categories of cases. Track B, which we anticipate from experience will be the majority of cases, is where parties do have issues, but appear that they have the ability to reach an agreement with a relatively low level of services from the court. And when I speak about services from the court, I'm talking not only about the kinds of services that Joe went over briefly that family services offers, but also court time, hearing time, and trial time where that's needed. Most cases ultimately resolved by agreement without need of a trial. The cases on track B might need some mediation services from family services to get to an agreement. But we don't expect that they will need a lot of court dates or court time. Track C would be the cases that appear to be in need of the highest level of court service, including more intensive services from family relations like custody evaluations, and more court time, including trials. Next slide, please, Deb. So after the triage, the court will issue a scheduling order. Again, we don't really need one for track A. For track B, that scheduling order, which would be a set of preset court dates that the parties would know up front, would include a next court date, roughly 30 to 60 days after the resolution plan date. We call that a case date. And on that case date, the court could consider any pending temporary motions that the parties have filed that they are ready to have considered, to perhaps hear reports back from family services on work that family services might have done in the meantime, to see if the parties are ready to resolve the case at that point. Also, at the resolution plan date, the court would set a schedule for discovery for the exchange of information to get that going right away so that the ultimate closure of the case is less likely to be delayed by the fact that one party hasn't provided the information they're required by court rules to provide to the other. When the case date arrives in a Track B case, if it has still not been resolved, if the parties aren't ready to go to judgment on their divorce, at that point, typically the judge will set a trial date. And that date is likely, given court scheduling, to still be a few months away, to give the parties some more time to try to work out their issues. And the court would also schedule a final pretrial settlement conference date prior to the trial date in an effort, with the help most likely of a judge, other than the judge who's going to be hearing the trial, to help guide the parties to a settlement if they can reach one. So that would be the framework of dates that are preset in a Track B case. In a Track C case, where we expect a higher level of resources to be needed, it's likely that, first of all, right after the resolution plan date, services from family relations could be ordered, including a custody evaluation, if it appears that that's what the parties need to be able to pursue their resolution. And under the old process, it was not common that a custody evaluation would be ordered so early in a case. The case would sort of meander along for a while on a few short calendars, and after several visits, family relations would realize these parties need a higher level of service and suggest to the court then that an evaluation was required, or the parties themselves might suggest it. With the triage, we will identify sooner when something like a time-consuming custody evaluation is needed and order it sooner to get that in place so that the case can be concluded sooner. Excuse me, for a Track C case, the court would set 2 case dates at intervals over the expected life of the case for the same purposes or similar purposes as in a Track B case, including considering any pending temporary motions at each one. To give you an idea of the length of time that's expected, at least as long as we are continuing to operate in the virtual world, we expect that case dates for Track B cases will likely be about 30 minutes in length. A judge could always order a longer case date session, but the default is going to be 30 minutes. For Track C cases, the default length will be 90 minutes. So compared to the average 6 minutes the parties could have gotten on a short calendar, we expect that that will be significantly more time that would enable the court to actually conduct more hearings on temporary motions, or even begin hearings if more time were needed, than ever could be done on the short calendar. The other differences between a Track B and Track C case is, as Joe mentioned, in a Track C case, there will be a designated judge in a multi-judge court, a designated judge assigned to that case for the life of the case, at least up to the point of trial. A different judge might hear the trial, but that designated judge would be the one who would be present at every case date, would consider temporary motions, would know the history of the case. And there'd be the dedicated family relations counselor if there were parenting issues involved, as would be likely in a Track C case. The other main difference is that for a Track C case, the court at the outset will set trial dates. Those trial dates will be roughly 1 year out from the return date. And that's for a long time been the national standard that we should try to resolve divorce cases or family cases within 1 year from when they're commenced. By giving parties the trial date so soon, we accomplish a couple of things. One is that we let them know that there is an end in sight, and help them to focus on resolving their overall case and not conducting an indefinite battle of temporary motions. It lets the parties know that there's an end of the road that they can work toward. It limits the amount of time the case is pending, during which more and more issues tend to arise in between the high conflict court dates. And it also avoids the further delay that would otherwise happen if we waited until farther on down the line to set trial dates, because then the likely available dates would still be months away, as opposed to locking in at least we expect 3 days for trial in an average Track C case. So that's the main difference between Track B and Track C. Motions that are filed along the way would automatically be up for consideration at the next already scheduled court event, like a case date. Now, one misconception I think that's out there is that this is all the time the parties will get. And in a Track C case where there are a lot of issues, 2 court dates of 90 minutes each along the way, plus the pretrial settlement conference, plus the trial. It's nice to have those in place, but that's not enough. And we recognize that. We are not intending that these would be the only court dates. There are other ways that additional court dates could be needed, but they would be set by the court, and in a Track C case, set by the designated judge who is very familiar with that case and sensitive to its needs. If a party filed a motion and it was of an urgent nature or a time-sensitive nature, and the next case date were not for 2 months away, for example, that party has the right to file a request for an earlier hearing date on that motion, stating the reason for the urgency, the estimated time needed to hold the hearing, and dates of availability of that party prior to the next case date for a hearing. And then the opposing party would have the opportunity to file a similar statement. The designated judge could then review it, make a determination as to whether this did seem to be something urgent that required an earlier date, and would have the information from both sides to enable it to be scheduled at a time when it really could be heard, as opposed to the parties appearing at a short calendar when we know there isn't time for a long hearing just to request a hearing date. There are other things that are required by law to happen within certain periods of time. And if that's the case, we will observe those time limits, even if the next previously set court date doesn't fall within those limits. And finally, on a case date, just like that short calendar, it may well arise that there is a motion that requires a hearing and that 90 minutes is not enough. And the judge, just as he or she always could, may schedule a specially assigned hearing of appropriate length at a later date. But the benefit of the scheduling order is that it sets a framework for the case. It sets an end date, and it has certain checkpoints along the way where most motions can be addressed without making the parties come to court each and every time a new motion is filed. Next slide, please. Yeah. Just a few concluding remarks before we'll try to address any questions the committee may have. One thing I do want to talk about is that the pandemic had an impact on our plans for this new process, just as it did everything else. Our goal had always been to have this new process in place by January 2021, and that's in fact what we did, but it happened in a way that was not what we intended, and in many ways was not ideal. We were working with the National Center for State Courts. We were reaching out to stakeholders. We had met with domestic violence advocates. We had met with some family attorneys from around the state. At the end of January of 2020, representatives from the National Center for State Courts had a 2-day site visit, 2 full days of meetings with us and other stakeholders, talk about the plan and try to refine our approach and come up with something specific that we could then present on a broader basis to stakeholders. We spent the month of February of 2020 working on that plan in light of what we had learned during that site visit, with the goal of, during the spring of 2020, having an extensive outreach to the family bar, to other stakeholders, including, importantly, the public, because, again, they're the ultimate people impacted by this, and they also represent a majority of the litigants who are self-represented. The pandemic obviously made that impossible. We suddenly had to turn our attention away from outreach and information dissemination about our new process to dealing with the pandemic, trying to figure out ways to keep operating with the restrictions on activities of the courthouse. And we weren't also able to do the training that we had intended and planned. That training was slated to occur during the latter half of 2020, after we had conducted the outreach, gotten suggestions, made some changes in the plan based on that outreach. We were then going to be training judges, staff, other court personnel, as well as disseminating information among the public during the rest of 2020 with the goal of the January 2021 launch. The pandemic not only interrupted those plans and forced us to turn our attention to other things, it also made it impossible for us to continue with our old method of scheduling with the short calendar. At the beginning, when our operations were restricted, we went week by week discussing, can we have short calendar this week? And the answer was clearly no. And after several weeks of that, and as more information came out about the scope of the pandemic, it became clear to us that we could not sit and wait for short calendar to come back to start scheduling matters, that we were working feverishly with our excellent IT staff and our court operations people to devise ways to hold proceedings virtually. But short calendar was not something that could ever be done effectively in a virtual way. So we had a need for some new scheduling methods right away that were more conducive to virtual scheduling. And happily, the methods that we were already talking about for other reasons for the new process fit that bill. We were going to be calling in fewer litigants at a time for longer proceedings. And that meshed very well with the way it was necessary to set up virtual proceedings. So we ended up, of necessity, phasing in different elements of the new process so that we could use those scheduling methods to address the cases as best we could. And things changed rapidly. Our IT capabilities changed rapidly. We incorporated new features as that was possible. The one thing that we couldn't incorporate early on were the resolution plan screenings, because that was dependent on some specialized training for family services, which had been delayed, but ultimately was done virtually by the end of 2020. And that was the last piece of the puzzle that we were able to introduce fully by January of 2021, so that by then we did have the process fully implemented. But we had to do it without the benefit of the outreach to stakeholders and the comments and the suggestions from them, without much opportunity for advance information. We were working on the fly and doing as much as we could, as quickly as we could, to address the immediate needs of litigants in cases. So it was not an ideal way to roll things out. But now that we have the process in place, we're resuming the outreach that we had intended to happen last spring. We're going to be speaking with attorneys in the family bar, going back to speak with domestic violence advocates, again, reaching out to the public. Hopefully mental health professionals will give us some feedback. That is ongoing, and I know there will be some tweaks and changes in the process. Some of the time limits that I've talked about today for scheduling right now are difficult to achieve because of the backlog of cases resulting from the pandemic. From March through midsummer last year, we really couldn't do any hearings except the very direst emergencies like restraining orders and emergency custody hearings. So we have some catch up to do before we can meet those time interval goals. but I know that we'll get there. When we're able to resume in-person proceedings in court, as public health conditions permit, that will certainly make it easier to schedule more matters more efficiently and help us to not only change some of the scheduling details, but to resolve the backlog more quickly. But although this is implemented, it's not in its final form in terms of all the details. And I regret that we haven't been able to do that outreach before we had to implement things. I look forward to doing it now. I understand the frustration of some who are involved in the process, that things have come out so quickly and without full and complete explanations. And I wish we had had the luxury of time to do that, but we didn't. And we're going back to continuing that now that we do have a little more time for that. But the important thing is that the basic principles of our new process are based on nationally recommended, proven best practices. We've already been a leader in using many of these processes in different ways, but the new process represents the first attempt to apply them from start to finish in a cohesive fashion. And we believe that the triage and pathways approach will take these nationally recommended principles, put them into practice in Connecticut, make it a system that's more efficient, that's less burdensome and expensive on the parties, and that most importantly leads to better outcomes for Connecticut's families. So I thank you for your time and listening, and certainly Joe and I will do our best to answer any questions that the members may have.
Thank you, Judge. First up, I have Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Judge. And
good morning.
Joe, I do remember when you were Family Relations Officer, so nice to see you again. You know, I will say that, you know, being somebody who does practice in this area, the waivers have worked. I had a case a few weeks ago where I was able to submit a final agreement 2 days after the return date, and also alleviate a court appearance. And I have to say that in that particular case, I think it would have been a difficult case because my client, who happened to be the mother, had been a victim of domestic violence, and the other party, you know, had a level of bravado that I think he would have wanted to display in court. So I was able to get everybody together and sign some stuff and get them divorced. But with that, you mentioned the tracks with regard to the filing of a new case. You know, many times in my experience, the divorce will go smoothly up to judgment, and then there's a flurry of post-judgment activity. Is there going to be a similar assignment of a matter once post-judgment activity occurs?
Yes, there is, and I thank you for asking that. I was trying to sort of simplify the explanation as best I could. There are permutations of it, but the same principles would be applied to a post-judgment matter. And Attorney Fishbein's absolutely right. In some cases, there's more activity after judgment than there was before. Problems arise. Parties file motions either to change the terms of a judgment regarding things like parenting schedules or custody, or to enforce orders that one party is allegedly not following. So when a case becomes what I'll call newly active on a post-judgment basis, it will get a resolution plan date and triage. The scheduling order will be a little bit different in the sense that the issues in the post-judgment matters tend to be more focused, and we don't anticipate a long period of pending litigation. And in most cases, the scheduling order after the triage will just set a hearing date. And the time before that hearing date will depend on the nature of the controversy and what has to be done to prepare for a hearing. If it's, for example, a parenting modification motion, and it's determined that we need a new custody evaluation, then a custody evaluation typically takes about 4 months. So we would probably set the hearing 5 months away. If it were something simpler, like a motion to modify child support, someone had a job change or other change in income, for example, if that can't be resolved at the resolution plan date, there might not be a lot of work that has to be done to prepare. It might just be getting the matter before a judge with the pertinent financial information and letting the judge make a decision. That hearing could be as early as 3 or 4 weeks away. And in the interim, if there are services needed, they can be ordered. So it's the same process. It's just some of the elements of the new case process, like these interim case dates, will not generally apply to a post-judgment matter.
Thank you for that. The previous to this new format, pro se as well as practitioners were able to sort of calendar their lives. I knew if I filed a motion in, let's say, your court in Middletown, and on the same day a motion in New Haven, I knew that New Haven did contempts on Wednesdays and other stuff on Thursday, and that your calendar was on Monday. But under this present system, all of a sudden I get a notice saying on some day at some time I have to be around and available. Is there any rhyme or reason to that I as a practitioner or the general public can rely upon to say, well, I might be scheduled for that day instead of 5 days a week?
The two things I'd like to say. One is that when we establish what we call the case date days in each court, most, if not all, courts in Connecticut now have 2 days a week that are devoted to these case dates that we've talked about. And they were designed in such a way as to try to avoid courts in close proximity to each other having both of the same case date days each week. That's why different courts have their case dates on different days of the week. We recognize that there are attorneys who may practice in 2 or 3 different courts in the same general area, and we wanted to avoid situations where that attorney was constantly being called to court for case dates on the same days each week in all of those courts. But more importantly, the difference that I expect to see going forward is that up till now, we were using the case date scheduling method as sort of an emergency way in lieu of short calendar to get motions into court so people could be heard. Going forward, when you have your resolution plan date and the scheduling order is being made, you'll have the opportunity to have some input as to what the case date will be. And while there's a certain time range within which the case date should fall, it doesn't have to be on an exact day. It's got to be within an acceptable range. And if you know you already have, as an attorney, a conflict on the 3rd Wednesday in April, then maybe you ask for the case date to be on the 4th Wednesday. And you'll know your schedule farther in advance than has been the case so far. So we're hoping that that will alleviate the stress on attorneys and allow them to plan their schedules so that they are able to avoid conflicts. Also, by not having you to make you expect to spend your whole day in court, like you might have had to expect on your calendar, you'll either have a time slot that's designated or a part of the day, which should help to coordinate different cases in different courts, so there's not a conflict. I can say that the short calendar, while the filer of the motion knew when it would come up, the other side didn't. And the court, in the couple of days leading up to short calendar, clerks and case law coordinators and judges spent an inordinate amount of time reviewing and deciding on motions for continuance of a short calendar day because somebody had a conflict. And that was another wasted effort with time that could have been put to a better use. So we want to give parties more input up front into what the schedule is so that they can try to avoid those conflicts and have more advanced notice of the date so they can plan for them.
Well, thank you for that.
If I may, Judge, I'm sorry, Representative. In terms of family services, our initial screens are going to be assigned to one specific day of the week, so that as this goes forward, the attorneys are going to know family services is screening on Tuesdays in a particular court, and we tried to be as sensitive for the courts in the same area so that that's a possibility. So we picked a day or a day, depending on the volume, where attorneys would know that's the screening day for family services.
Thank you for that. Is there any consideration to having a discovery calendar? You know, civil has sort of broken out into various different calendars, and I know like yesterday I had to file a motion to compel to get some discovery production that had already been ordered by the court. You know, I would think there would be a procedure by which that motion, although I have a pro se on the other side, could be addressed, let's say, if it is not responded to by the other side within a certain period of time. I mean, or that just discovery things are dealt with on the same calendar, because I guess under the current situation, that motion to compel, although necessary to do financial orders, is going to go in the hopper with other motions that have to do with financial orders. So it becomes a little cumbersome.
There are a couple of points. One is that I didn't mention this in my discussion of this Track B, especially scheduling order. But the other feature of the order is that there will be a separate date set for a discovery conference. So that even if there's no dispute, there would be a conference. It could be just a remote conference with counsel, now that we have the technology, at around the time that discovery should be complete, just to see if there are any issues that need to be addressed, and try to nip them in the bud and get them resolved so that they don't come up on eve of trial and cause a delay. As far as motions relating to discovery along the way, the plan is that family is going to treat them more like the civil side does, in the sense of dealing with on the papers those which can be done in that fashion without necessarily having a date for argument by counsel. And a judge could decide that it's not clear on the papers what should happen. But if it's simply a motion that says the defendant was supposed to give me their responses to discovery by February 25th, and I don't have it yet, I'd like an order that they do it within 10 days. Well, that might be something a judge can just order without making anyone come into court either in person or virtually. Otherwise, a discovery motion is one of the things that could be considered on a case date. But if it were more urgent than that, and argument could be helpful to the judge, that's something that can always be specially scheduled at an earlier date.
I thank you for that. And my last question is, the cases that were pending March of last year when the pandemic hit, you know, I had a couple trials that were scheduled for March and they got put off. They were actually hearings. One was a trial, one was a hearing. How does one get those back on track if the court really, if there are important things in there and then there's minor things? And my example is, in one of those cases, child support was over calculated that the mother is paying to the father, and we've asked for that modification. And instead of utilizing self-help and just modifying by herself, this motion, along with other motions, have been sitting out there for a long time. I know you did mention there's a request to expedite or to bring it to the court's attention. Is that what one would file?
If you had a matter that was already scheduled for a final hearing or a final trial before the pandemic hit and was canceled because of that, I would suggest you contact the caseflow coordinator in that court and ask him or her to speak to the presiding judge about getting a new date. We did try to reschedule as many things as we could. In some cases, it was difficult, especially with post-judgment motions, to know whether the parties were still going forward with the motion. So if you have a case where there's been no contact with the court, then I think a case flow request or an email to the case flow coordinator just indicating what the matter is and that it was scheduled for a hearing that didn't happen, and you still need a hearing.
Not to drill down, but we did have a conference with family relations and it didn't come to an agreement. And I will follow your direction and see where we get. So thank you, and thank you, Mr. Chairman.
Thank you, Representative. Representative Quinn.
Thank you, Mr. Chairman, and thank you, Judge Albus, for putting something like this together. Family law is not an area that I practice in, but I do appreciate a consistent system being designed for all of the judicial districts in the state. The question that I have is on your Track C cases. I think it's a great idea that it's assigned to one judge and one family relations officer, but how are you going to handle the situation of, a case that starts in June, let's say, gets assigned to a judge, and then there's a real possibility that in the 1st of September, that the judge might be transferred to another district? Are the cases going to follow the initial judge, or is the whole reassignment of judges going to change as a result of this?
Questions about the assignment of judges are a little bit above my my pay grade, but certainly that's an issue. And the civil division has had the same issue with individual calendaring, and I think that's something that is taken into consideration in reassignments. I don't think it's likely that we will have cases follow judges, because ultimately that could lead to a lot of confusion and inconvenience for the parties. But there certainly would have to be some method of handing off, if a judge were transferred, his or her Track C cases to a judge coming in to be brought up to speed on it, to be able to step in and take over. So it is possible that the reassignment or the retirement or illness or other unavailability of a judge could mean that the parties do see a different judge at some point. But we have had a pilot project of individual calendaring for family matters in Norwich that seemed to work quite well, especially on the more complex cases. So I expect it will. We certainly will have to make adjustments. It's a good question. And we'll just have to address that as it arises and make sure that if a judge can no longer handle a Track C case, that someone is made familiar with it enough to step in.
Okay. All right. Thank you very much. That was just my only question. And again, I greatly appreciate your efforts in designing this system.
Thank you.
Thank you, Representative Quinn. Representative Pavlik-Tomato.
Thank you, Mr. Chairman, and good morning, Your Honor. Thank you.
Good morning.
For coming to talk to us. I had a question about, is there a requirement that the parties make a good faith effort to attempt to resolve their issues prior to any hearing? I'm not sure if I've ever seen that before.
Well, I wouldn't think of it as a requirement. We want to give them the opportunity. And the nature of the process, especially with the screening in the beginning, is to give them that opportunity and to gauge their ability to come to an agreement. If it doesn't happen on that date, then Family Services might recommend a mediation service by them in a case to work with the parties more to try to reach them, help them reach an agreement. So there are efforts to do so to help the parties recognize that certainly reaching an agreement is a viable and favorable option. But I don't know, nothing in the new process says you have to try to reach an agreement before we'll give you a hearing.
Yeah, I've had that experience where the family relations does then step it to a mediation. I've just in other courts have had to, put something at the bottom that says, I have attempted to reach out to the attorney and solve this matter. And I just find that there's some attorneys who don't respond for whatever reason. And I always, even before family relations, try to make an attempt to, at least talk about the issue and see if we can reach an agreement. But it's sometimes hard to get other parties to respond. So
that's not a feature of the process. I suppose the only other feature of the process that we do have that you could say is to make parties try to reach an agreement is if they are ordered to attend a judicial pretrial settlement conference. But they're still free to agree or not agree. We just want to provide as many opportunities for that kind of resolution, because generally, especially in family cases, these people still have to live together and cooperate going forward. And sometimes the mere fact that a contested trial was held can damage their ability to do that effectively in the future in ways that it's best to avoid. And I always tell parents, these are your children, this is your family. I can't possibly make as good a decision about your children as you could make if you put your heads together and put aside your personal priorities and think about what's best for them. I just can't do it. And you really should give it the effort of doing it yourself. I'll do the best I can if you can't. But you're the parents, and this is your role, not mine.
I agree, and I tell my clients exactly that. I was thinking more in the line of attorneys, I think, when it comes to actually communicating. But yes, I definitely tell my clients the same thing, so I appreciate that. My other question was about motions for contempt, whether it's pre or post final judgment. I was wondering if those are, I don't want to say a problem, but maybe a problem, or if you find a high volume of them, and if there are serial filers for motions to contempt, if their courts or judges have been, I don't know, whether awarding attorney's fees or doing something so that way it's not just something that is, somebody doesn't file 12 in a row and kind of take advantage of the system, as, because if the other party has to pay attorney's fees, and, how the court's handling that, if at all.
Well, for one thing, under the new process, if that party files 12 in a row, that doesn't mean they're coming to court 12 times. They may come to court once. And if there are 12 very similar motions for contempt, if there has to be a hearing, maybe there's one hearing on all 12 as opposed to 12 visits to court. Certainly the statute gives a party who successfully defends a motion for contempt the right to seek attorney's fees. That's been there as long as I've been a judge, and that's always an option. And ultimately, if someone is perceived to be abusing the process, a judge has the leeway to restrict their filings and require that they get leave of court first. So it is a problem, and it's one of the reasons we decided on having these preset court dates to which non-time sensitive motions could be taken up, rather than making everyone come to court on a busy short calendar day every 2 weeks.
All right, thank you very much. I appreciate that, and I appreciate all the hard work for that you've done, and to make this process more successful and easier on all of us. So thank you.
Thank you, Representative. Senator Haskell.
Thank you so much, Mr. Chair. Good morning, Your Honor. It's good to see you.
Good morning. Nice to see you.
Just a very quick question for you, if you don't mind. I appreciate the reforms that you've outlined today, and I've learned a lot from listening. I am vaguely aware that in some other states, at least in New England, throughout the family relations process, there may be actually a requirement to seek private mediation at a reduced rate, of course, and help resolve some of these disputes out of court. Is that something that the judicial branch has considered in Connecticut? I recognize it's not a part of the reform you've outlined today, but going forward, do you think that there might be a place for that in Connecticut? Of course, mediation won't work for all families, but to the extent we can encourage them to resolve those courts without costly litigation, it seems like a win-win.
There are states that have that requirement, I'm aware. And not to pass the buck, but I think that's probably a legislative requirement. I don't know that we can tell people you can't file your action until you've tried to mediate. I don't think we have that authority. They have the right of access to the court. The right to file the case exists. We certainly, through family services, especially at the initial meeting, make parties aware of the options there are for resolving their issues. We have general information sessions, and mediation certainly is one of the options that people could be made aware of. But I don't feel that we have, and I haven't researched this, but my initial reaction is that if there were to be such a requirement, it would have to be a statutory requirement, because the statutes now allow someone to file.
That's perfectly reasonable. Thank you so much, Your Honor, for your time and for your perspective today.
Thank you very much. Good to see you again.
Thank you, Senator Haskell. Judge Albus, a couple quick process questions.
Sure.
First, on that issue of kind of resources, I think it was mentioned earlier, there's about 130 family relations counselors in the state. It seems like this new system is going to put quite a bit of onus on them up front. Do we have enough family relations counselors in order to handle this workload that's anticipated?
I think I'll defer to Joe on that, and then I'll add anything that I feel I should add. Joe, can you address the staffing level?
Of course, Your Honor. I mean, we're very fortunate at Family Services, within the Court Support Services Division. We have a lot of support from Judge Carroll and Judge Bizzuto. We have, every time we have a vacancy, it's backfilled. The process was developed knowing that the amount of family relations counselors we have are going to do the upfront work as well as the additional work from the services that the court orders from the bench. So I think we have adequate staffing. If it becomes an issue, certainly that would be something that our executive director, Gary Roberge, would address with Judge Carroll and Judge Bizzuto. But at this point, I think we have enough staff.
And is there, a level of training that is going to be necessary for the family relations counselors? I assume there's some sort of criteria that they are going to look at to determine whether a case goes on, track 1, 2, or 3. What sort of training are they going to do? And is there criteria that they're going to use with respect to those tracks?
So I'm sorry, Your Honor. So we're very fortunate. The skills that a family relations counselor has used in the old process, when we negotiated, when we dealt with the parties, those same skills are transferable to this new initial meeting. Family Services doesn't necessarily need to learn new skills. We were fortunate to have the National Center for State Courts and an individual by the name of Dr. Michael Saini from Toronto, who came and did a training for the family relations counselors and our supervisors on how to actually triage and perform that initial meeting so it is successful. We have a questionnaire that we also have we've developed with the help of the National Center for State Courts, which provides some information and some questions that the family relations counselor can use that is built on science to really determine the level of complexity and the level of conflict. And that is really the issue that we will use to determine our recommendation for a track. Family Services has been doing triage since 2004. But triage within, and that's again another example of differentiated case management. If a case is referred to Family Services and we're going to recommend mediation or an evaluation, we have a screen that is validated that we use to make those determinations. Screens, along with our professional judgment, were very successful in putting parties in the right service. And my hope is that as part of that initial screening, the same is going to occur and will predict accurately the amount of court resources that are necessary moving forward so that parties can exit the system as quickly as possible.
I guess my question was less about the skill and dedication, which I have no doubt about. My question was whether there's kind of a metrics or criteria that they're going to look to so that there's some level of uniformity kind of across the system, as opposed to, one family relations counselor who may view things one way as opposed to, another, and you end up having, if you get family relations officer Smith, they think everything's a category C case as opposed to the family relations officer Jones, who sees everything as a B case.
So fortunately for us, our screenings are going to be in our case management system, and where we'll be able to determine, based on our initial prediction, what actually happened to those cases, what services in the future family services was asked to complete. So if we said, like the example that you brought up, every case is a C-track case, and a family relations counselor put all those cases in the complex track. Ultimately, we'll know if those cases resolve and how they resolve through our inputting into our data. So we'll be able to get data to see how effective our predictions were. And if a counselor did that and didn't really follow the screening and the questionnaire, we'd be able to address that.
If I could just add, I'm sorry, if I could just add briefly. No. The other considerations are, if either party doesn't agree with the recommendation, as we said before, they have the right to be heard by the judge as to the track assignment. And also, there's nothing that would prevent a judge, with or without the recommendation of family services, from deciding once a case had started that it needed to move to a different track, either because perhaps it wasn't assigned to the right one to start with, or more likely, things have happened since that have changed the nature of the dispute. So we have flexibility, and I don't think anyone should look at this as being a case where there is a track that's good to be on or a track that's bad to be on. We're just trying to give each case the track that best fits that case. And there's no inherent advantage or disadvantage of being on a track unless you need more resources and you're put on track B. And if that becomes apparent, a change will be made.
All right, we got about 12 minutes left. I do have a question to left, but in the interest of time, I'm going to shift to Representative Callahan and hope to squeeze it in at the end. Representative Callahan.
Thank you, Mr. Chairman. Just a brief comment. Thank you, Your Honor, and thank you, Mr. DeTuno, for being here.
Hello, Representative Callahan. How are you, sir?
Good. I just want to recognize you one of the most capable people I worked with in judicial over the almost 30 years that I did work there. And it's good to see you, and I have every bit of confidence that these changes can be flawlessly implemented. And I appreciate you and Judge Albus coming in this morning to talk with us. Thank you.
Thank you, Representative.
I see Representative Fishbein, I hope, has another quick comment, but is there anybody else who's not had a chance the first time who wants to? If not, Representative Fishbein?
Yes, thank you, Mr. Chairman. Quick comment and question. First of all, family relations is already well aware of screening. They screen conflict cases all the time. Any case that goes for an evaluation. So I know the family relations officers are very adept at doing that based upon a scoring system. There's already mediation in our process. I tell people all the time that when you meet with family relations, you're meeting with somebody who's skilled in mediation. And as Mr. DeTuno said, they resolve about 60% of the disputes walking in the door, which is a credit to their mediation. But to go back, Representative Pablo Tomato, Judge Albus had asked you about the utilization of the contempt process, and I run into this a lot. Where you'll get an individual who, let's say, makes a decent living, the other spouse is home with the children, there's an order of child support, and the individual doesn't pay the child support. It's a level of control. Contempt needs to be filed. That person who isn't working, relying upon the child support, has to hire someone to represent them, and they can't afford it. And it happens time and time again. And I understand our statute right now is permissive. The court may order attorney's fees if one is found in contempt. I did put in a bill this session to make that stronger and to add shall. And I would just like to know how you feel about that possible change. I did kill my own bill this session, but I did throw that out there. So I'd be interested to learn from you, sir, how you would feel about taking away the level of that discretion.
My concern is that if a bill, for example, says on a motion for contempt, the prevailing party shall be awarded legal fees. A motion for contempt can involve multiple issues. And it's not uncommon, for example, for the court to find that, yes, there was a violation of the order, yes, there's some money due, but it was not a willful violation within the meaning of our case law under the high standard of proof that's required. So the court doesn't find contempt, but orders payment of the arrearage. I can see both parties in that case claiming that they prevailed. The one who owes the money can say, I prevailed. It was a motion to find me in contempt, and the court didn't find me in contempt. So I think ultimately it's a legislative decision, but I would just suggest that an effort like that needs to be clear so that it can be applied to situations where there are multiple issues or multiple elements of an issue, and that some parties may prevail on some issues and others on the others. I think it's hard. I think it could lead to difficulties in application if it's a broad brush rule, because in most family matters, both sides can claim that they prevailed on something.
No, I thank you for that answer. And I'm not talking about where there's a lot of issues, but like, I recently had a case where there's an order to pay college, and there's millions of dollars to pay for college. The individual didn't pay for college, and it was 5 days of hearing. That's very costly for the mom in that case, who is relying upon her child support, small order of alimony, who's got to pay thousands of dollars. And ultimately the court says, he's in contempt, but it's discretionary, on the order of attorney's fees. So I understand the answer, sir, and I thank you for being here today and all the information you've given us. So thank you, Mr. Chairman.
Thank you.
Thank you. All right, if there's nobody else, and in the interest of ending on time, which I know is a novelty here in the General Assembly, at least. Judge, I want to just conclude by asking a couple, like I said, process questions I didn't get to. So on this new track system, are there any legislative changes that you need from us?
No, the system is based essentially on the court's inherent authority to manage its own docket and issue scheduling orders. I do believe the court operations bill that we've proposed this year includes a provision or two where there's a reference to a court calendar and calls it the short calendar. And while we have calendars in this process, we don't have anything we're calling the short calendar to avoid confusion with the old process. So my recollection is we asked that the word short be deleted and still have the same requirement that something go on a calendar, but not that it be called short calendar. I don't see that change as something we need to do this process, but it's in some ways related to the process.
And I assume there are rule changes that you will be going before the Rules Committee with this?
There are. I did propose some rule changes, again, not to codify this new process because it's still in flux and it's new. And we always, even before the pandemic, anticipated that we would wait to gain from the benefit experience, see what adjustments need to be made before we went to the Rules Committee to ask for rules to codify the new process. We have, I did ask for some rule changes, again, along the lines of eliminating existing provisions that we don't need in this process. And an example is, I mentioned early on in my presentation, the case management date. and there was a requirement that at that date, the parties file a case management agreement. Under the new process, we don't really need that, and didn't see the need to make parties keep filing that, because we would have already essentially done that case management much earlier on at the triage. So it's not a rule change that we need in order to do this process. It was a rule change that I thought made sense in view of the new process. I do expect that after this has been in place and we've made adjustments, that it would make sense to codify the basic features of it in the rules. But that's anticipated at a later date.
Okay. And Judge, just a couple, I mean, as I think you alluded to, there has been some, I guess, concern raised by practitioners on this. I know I've been, I was forwarded a copy of a letter that was sent to you on February 1st from the Connecticut Bar Association's Family Law section. I think a number of the concerns they raised, you seem to have addressed in some way, shape, or form today, but I would encourage you sooner rather than later to sit down with them. As helpful as it is to brief us, certainly folks who practice in the family courts day in and day out are probably even more important to brief on this. And I'd encourage you to meet with them. We've also heard, the committee's also heard concern from some of the legal aid organizations, I think predominantly on the issue of being able to get in and get an early child support order, or to get early parenting direction. It concerns me as much as I appreciate the work that has gone into this, and I appreciate the work the court system has done trying to manage through the pandemic. It does seem like a lot of time was spent consulting with national experts on this, which can be helpful. But I am concerned that some of the local folks who this process affects to the greatest extent, including our local attorneys in the state and legal aid organizations and who they support, at least have the feeling that they've not been heard. I'm not here to pass judgment on whether they have or haven't, but I think it's important that we in government, both branches, listen to those voices first and foremost as we work through finalizing this process.
I agree, and that was the intention before the pandemic disrupted the sequence of events, and we are resuming that effort now to talk to stakeholders, and primarily among them are attorneys. I recognize that. And then there are legitimate concerns, and we're open to discussions and constructive suggestions.
Representative Dubitzky, we have like 30 seconds. Is it a quick question, or can we do it offline via email?
One quick question, and I apologize, I was in another public hearing. We have heard quite a bit from people who, from pro se litigants, who believe that the judges are biased against them, and especially in cases where there is one side has an attorney and one side does not. Is there anything in your new system that makes it so pro se litigants will feel less oppressed, for no better term?
Well, Representative, I would disagree that judges are biased against pro se litigants, but
I'm not taking a position one way or another. I'm just saying that's what we've heard.
I understand. Certainly the new process was designed with a keen awareness of the number of pro se litigants that we have in Connecticut and their needs. And the informational piece of that first court date, the resolution plan date, is one of the ways that we hope to address that by providing information up front so that self-represented litigants have a good idea of what to expect along the way and what their options are. and to have the opportunity to be prepared, even though they don't have an attorney, as best they can for each step in the process. And we continue to have our excellent court service centers available to assist self-represented litigants with parties. So it is my hope that if self-represented litigants have felt that they've been in an unfair position before, that they will have more information at their disposal at an earlier point in the case and not feel that way.
Okay, well, thank you very much. I appreciate it. Thank you, Mr. Chairman.
Thank you, and thank you both. Thank you, Judge Albus. Thank you, Mr. Tuno. We greatly appreciate your time and attention to this, and we will we'll certainly look to follow back up as the process rolls out and as you get more feedback and hopefully buy-in from some communities that this process affects. So thank you all. We'll leave it there. And as a reminder to members, we will be back on at 12 o'clock for a public hearing on various bills.
Thank you.
Thank you all.